Hello, my name's David Winch and I'm a forensic accountant with Barfield's Forensic Accountants. And today in this webinar, we're going to have a look at trial evidence and how it varies and differs from confiscation proceedings. So let's have a go. Quick look at the agenda. We'll start with an intro and then talk briefly about the 2-year time limit in section 14 of the Proceeds of Crime Act 2002. Then we'll move on to the burden and standard of proof and the period covered by the trial and the period covered by the confiscation proceedings and the criminal conduct covered by the trial and the criminal conduct covered by the confiscation proceedings and how those differ. Then we'll talk about who is the fact finder in confiscation proceedings and in trial proceedings. Talk about the consistency or sometimes perhaps a lack of consistency between facts found at trial and facts found in confiscation. And finally, a little chat about evidence which is inadmissible at trial and how that's dealt with in confiscation. And of course, I'll talk finally about how Barfield's Forensic Accountants can help you. Okay, so an overview. Let's think about the defendant's situation when he is facing confiscation proceedings. Obviously, he has just been convicted at trial. And there are all sorts of emotions perhaps connected with that, whether it's been a guilty plea, whether it's been a trial in the magistrates, whether it's been a trial in the Crown Court. The defendant may have lost confidence in his legal team, or indeed he may change his legal team and have a different legal team dealing with the confiscation proceedings. And of course, having been convicted, he may be in prison, and that causes some difficulties in communicating with him, in getting him to look at documents and in getting information from him. He may also be facing financial issues with the legal aid agency. He might have a capital contribution to make following conviction. He may be facing a claim for prosecution costs, particularly in my experience, where the prosecutor is a local authority. And of course, he may be considering an appeal against conviction or against sentence or both. So generally speaking, confiscation proceedings are not going to be welcome. The last thing he needs is confiscation proceedings to deal with, but that is unfortunately the situation he is in. So as a lawyer advising somebody who's facing confiscation proceedings, you do face all these difficulties. There's a 2-year time limit in section 14 of the Proceeds of Crime Act 2002. And I should say that I'm talking all the time here about the Proceeds of Crime Act 2002 as amended and as it applies in England and Wales. There are some slight differences in Scotland and in Northern Ireland, but I'm just confining myself to the England and Wales version, and therefore the England and Wales section numbers. So under section 14, POCA provides that the court may proceed under section 6, and section 6, of course, is the section that deals with the making of a confiscation order. The court may proceed under section 6 before sentencing, or it may postpone proceedings. And postponement may not exceed 2 years after the date of conviction. Note that is the date of conviction, not the date of sentencing. So that, on the face of it, is a fairly straightforward proposition. But actually, not quite that straightforward in practice, because the 2-year time limit can be exceeded where there are exceptional circumstances. And in the past, courts have been very ready to find exceptional circumstances. Now, what should happen is that there should be a postponement, and then there should be, before that date expires, either a confiscation hearing or a further postponement. And there have been cases in the past where, for one reason or another, there's not been a further postponement, the time limit has expired, and then people have said, hey, confiscation is done. We can't have confiscation now because the time limit has expired. And the courts have not relished that interpretation. And they have generally found that if a time limit has been missed, it's not fatal to the whole confiscation operation. And indeed, the legislation was changed a few years ago to make that clear. What I would say is, obviously, COVID has undoubtedly created exceptional circumstances. And I don't imagine any court is going to have any problem finding exceptional circumstances, allowing it to exceed the 2-year time limit. But I also have to say, the Law Commission, in a recent consultation on confiscation, put forward their interpretation of what this means. Now, most people that I have dealt with have assumed that where it says the court may proceed under Section 6, what it means is the court may make a confiscation order. And so that the 2-year time limit, amongst people I've known, has always been assumed to relate to the time before the making of the confiscation order. Now, the Law Commission didn't take that view of Section 14. What they in effect said was that the 2-year time limit applies to the court deciding that it is going down the road of confiscation. So, for example, by setting a time limit for a Section 18 questionnaire to be completed, a time limit for a Section 16 statement to be served, and so on. And in effect, the Law Commission was saying, once the court has done that, it has proceeded under Section 6. And that's enough. It doesn't, in other words, the 2-year time limit, they're saying, doesn't apply to the end of the process, it applies to the start of the process. And they suggested, in the light of that 2 years was much too long, and the time limit should be amended to 6 months. Be that as it may, in practice, the 2-year time limit isn't a problem, isn't going to cause anybody to not be able to pursue confiscation proceedings, because the courts have said, in effect, it's not exactly advisory, but it's not fatal where it's missed. Right, let's talk about the burden of proof. The initial burden of proof is on the prosecution. And the initial burden of proof is on the prosecution in relation to the benefit of particular criminal conduct, that's the benefit of the offence. But what's sometimes less well understood is that the initial burden is on the prosecution in relation to the benefit of general criminal conduct. In practice, of course, the prosecution will also deal with the available amount in their Section 16 statement. In relation to the statutory assumptions, though, the initial burden, as I say, is on the prosecution, and that initial burden is to show that a transaction has occurred. They don't have to show why it's occurred under the assumptions, because the assumption is that if, say, a transfer has been made to the defendant, that is benefit of his general criminal conduct. They don't have to show that it is benefit of his general criminal conduct. They have to show that the transaction has occurred. And that is the relatively small initial burden of proof that rests on the prosecution. But it shouldn't be forgotten altogether. Sometimes I see Section 16 statements where that seems to have been altogether forgotten and overlooked, and the prosecutor has just blasted on as if he doesn't have anything to prove. That's not, as I understand the legislation to be, anyway. Once that initial burden has been satisfied, then the burden is on the defendant, of course, to rebut the statutory assumption. And generally speaking, the burden is on the defendant with regard to his available amount. But the court should look to all the evidence before it. So just because the court decides that it doesn't believe the defendant and doesn't believe his evidence, it's not automatic that it's going to find that the defendant's available amount is not less than his benefit. It's got to look at the evidence that's been brought before it from every source and then come to a sensible conclusion. There's case law behind that. I'm thinking particularly of the case of McIntosh, but I haven't in these slides detailed all the case law that's behind the commentary that I'm giving you. If you do want that case law, the final slide gives you my email address, and do email me and I will happily fill that in for you. Okay, done the burden of proof. What about the standard of proof? Well, matters are decided in relation to benefit and available amount on the civil standard, on a balance of probabilities. And we can find that in subsection 7 of section 6. So does that mean that if the prosecution says this is benefit and the defendant says no it isn't, that there is a 50-50 split and that the court is going to find in favour of the defendant and give him the benefit of the doubt? No, that's not the way that it's going to work. And the reason is that in practice, the court will have in mind that the defendant has been convicted of a criminal offence, and therefore it is likely to place little weight on unsupported evidence from him. What about the period and the criminal conduct? Well, the trial, of course, focuses on the indictment period, and it focuses on the criminal conduct that's on that indictment. It focuses on the alleged offending, the particular criminal conduct in the terminology of confiscation. But when we move on to the confiscation, particularly in a criminal lifestyle confiscation, which are the ones that mostly I deal with, I have to say, then strictly speaking, the position is this: the period starts with the day the defendant was born, and it ends on the day when the confiscation order is made. All of that period is a period which the court can have regard to when making a criminal lifestyle confiscation order and deciding the defendant's benefit. Now, I can almost hear you saying, hang on, that's not right. What about the relevant day and so on? Well, the position is that the relevant day is relevant to the statutory assumptions. And the statutory assumptions do not apply to the period prior to the relevant day. But that doesn't mean that the defendant may not have had any benefit prior to the relevant day. Of course he may. He may be a career criminal. He may have been convicted of 10 previous offences spanning back 20, 30 years. And his general criminal conduct is all his criminal conduct. And the benefit of his general criminal conduct is the benefit of all his criminal conduct. So where he has past convictions prior to the relevant day from which he has obtained a benefit and which have not previously been the subject of confiscation, they come in on a criminal lifestyle confiscation. Now, in practice, prosecutors don't usually bother with that. They usually stick to looking at the period after the relevant day. And the relevant day, as I'm sure you know, is generally the first day of the period of 6 years, which ends on the date these current proceedings were started. And usually the date when the current proceedings were started is the date on which the defendant was charged with the offence which he is ultimately convicted of, which triggers the confiscation proceedings. So in practice, normally you are not looking back prior to the relevant day. So that's why the Section 16 statement will focus on the period since the relevant day. But all of the defendant's criminal conduct can be brought in, can be relevant. So that's the position, strictly speaking. Okay, who's the fact finder? Pretty obvious, I think. At trial, the finders of fact are, in a Crown Court, are the jury. In a magistrate's court are the magistrates. But in a confiscation hearing where there is a contest, then the fact finder is the Crown Court judge. And he, of course, may be the same Crown Court judge who dealt with the trial if it was a Crown Court trial. Now, the defendant may not be very thrilled about that. He may feel that the judge's view is too much coloured by evidence that he's previously heard in the trial, or he may feel that the Crown Court judge doesn't like him, or whatever. But that is the situation. The Crown Court judge is the finder of fact in confiscation proceedings, as well as the decider of the law, obviously subject to appeal on legal points. Right, so we've had a trial and we're now having a confiscation. Is the court bound by its findings in the trial? Well, of course, part of the problem is that if you've had a jury trial, you don't actually know what the jury decided, other than they decided that the defendant was guilty or not guilty of particular counts. You don't know their reasoning, you don't know what they accepted and what they didn't. But the outcome of the confiscation proceedings should not be inconsistent with the findings at trial. Now, when I say should not be inconsistent, I don't mean has to be the same as. What I mean is should not be contrary to. So if we look at the prosecution opening or we look at the sentencing remarks, we may be able to divine from them what the findings were at trial on matters of fact. For example, if in sentencing the Crown Court judge has said, I'm sentencing on the basis that the defendant has stolen approximately £25,000 from his employer, then the confiscation proceedings shouldn't be contrary to that finding of fact. But there's no legal problem where a judge in confiscation proceedings makes findings of fact which go beyond the facts found at trial. That's partly because, of course, evidence can come into confiscation proceedings which was not evidence at trial. But there we are, you know, we're not limited, as we said earlier, to the indictment period. We're not limited to the charges on the indictment period. And the confiscation can go well beyond what was relevant at trial and what was found at trial. And so when I said the outcome of the confiscation proceeding should not be inconsistent with the findings at trial, they may go beyond the findings of trial. What about evidence which was or would have been inadmissible at trial? Well, that may be admissible in confiscation proceedings. The rules about admissibility of evidence that apply in a jury trial do not apply in a confiscation proceedings. The thinking is here that the judge will be able to direct himself as to any relevant legal issues connected with that evidence, and he will be able to assess what weight he should give to that evidence. And so he is, being, of course, an experienced lawyer, he is in a much better position to deal with what we might call inadmissible evidence than a jury would have been in a trial. And so for that reason, if you like, the gates are opened to him to hear that inadmissible evidence and to decide what weight to give it, if any, and whether there are any legal reasons why he should disregard it. Okay, so that's a fairly quick run through of some of the basic differences between trial and confiscation. I hope that is helpful. Just a reminder that Bartfield's Forensic Accountants is part of the Sedulo family of companies, and we offer a full range of financial services for businesses and individuals. On the forensic side, we undertake legally aided and privately funded criminal and civil forensic accountancy work with our team of experienced and highly trained forensic accountants, analysts and support staff, and using the latest IT facilities. We operate from offices in Leeds, Manchester, Liverpool office has just recently been opened, and in London. You can find more on this topic on our website. There are lots of blog articles, and also this and previous webinars can be found on the website in the seminars section. We'll send you a recording of this webinar. We'll email you with a link to it. And if you want to contact me, I mentioned my email address is on the screen there. Much better to email than to phone, quite frankly, because if I get an email, I can have a think, look up any relevant issues and background, and give you a much more reasoned and full answer than if you just phone me up on spec. The email address is there. The website also address is there for you. And thank you for your time. And we'll see you again in a fortnight or so. Thank you very much. Goodbye.